Hello. Thank you very much for joining us for the second webinar in our webinar series about responses to the COVID-19 pandemic. Today's webinar will focus on COVID-19 and constitutional rights. We are going to talk explicitly about the state-created danger theory and cruel and unusual punishment. And you have some fantastic speakers with you today. One of your panelists will be myself, Tristia Bauman. I'm a senior attorney at the National Law Center on Homelessness and Poverty. You'll also hear from Dr. Elizabeth Fry, who is an MD, as well as a Master of Public Health and a board member of the Street Medicine Institute, who has been doing street medicine in the Atlanta, Georgia area for a decade. And you'll hear from Lily Graham, litigation counsel at Disability Rights California, who will describe how the Law Center, Disability Rights California, and others are putting the state-created danger theory to work in a lawsuit against the City of San Diego, Bloom v. City of San Diego. Before we get going on the substantive part of today's webinar, just a little bit of housekeeping. The webinar will be recorded, so if you're not able to attend the entire thing, or if you want to refer back to it, you will have that option. We will have the recording up on our website along with all of the slides. So do feel free to reference those materials on our website. Also, we will try to make time for Q&A at the end of the presentation period. You do have the ability to submit questions in the dashboard to the right of your screen. Please do feel free to submit all of your questions, and we will try to get to as many of them as possible by the end of today's webinar. First, a little bit of context before we introduce Dr. Fry. Some of this will be familiar to those who are generally familiar with the Law Center's work. What this webinar aims to do is to talk about constitutional rights and theories to challenge criminalization practices. These challenges are always available, or have always been available, even prior to the outbreak of COVID-19. However, the elements of each theory are at least arguably strengthened during the pandemic, and we'll talk about how and why. But before we do that, I think it's important to root this conversation in the larger context. The reality is it is illegal to rest in most US cities. As you are likely know, the Law Center has been tracking a core set of 187 cities across the country, large and small, urban and rural, in every corner of the country. And since 2006, we have done a survey of laws on the books that punish the life-sustaining activities of people who lack housing. Some of the types of laws that we've looked at are laws like camping bans, sleeping bans, sitting and lying bans, and bans on living in vehicles. All of that data is set forth in our Housing Not Handcuffs 2019 report, which is the latest iteration of that report series. You can find that on our website. And you can also find all of the data that's set forth here. Rather than going through this, because I know some of this is already familiar to you, I will just point out that the private sheltering options that people have available to them when they lack private housing are often tents, makeshift structures, or vehicles. But using those tents, makeshift structures, or vehicles is a crime or a civil offense in most locations throughout the United States. For example, camping bans, which restrict use of tents, blankets, and also can restrict merely sleeping or resting temporarily outside, exist in 72% of the surveyed cities, and of those, 37% of those cities ban camping citywide. I'll also, down at the bottom of this slide, you'll see that bans on living in vehicles exist in 50% of our surveyed cities. The Bloom v. San Diego case that you'll hear about later involves a challenge to San Diego's restrictions on living in vehicles. But I want to note that while it's not the most pervasive category of criminalization ordinance, it is the fastest growing. And in fact has increased 213% since 2006 when we began tracking this category. Enforcement of these laws takes many forms. When we refer to criminalization of homelessness, people often think of criminal penalties. And indeed, people without housing are 11 times more likely than housed people to go to jail. So arrest and incarceration for performing life-sustaining activities is a reality for unhoused people across the country. But they're not the only forms of punishment. Fines and fees, move-along orders, sweeps of homeless encampments, property destruction. All of these are examples of the enforcement of the policies that we've tracked in our Housing Not Handcuffs report, and that may be subject to challenge, including under some of the theories that we'll talk about today. Why is it important to challenge these theories? To challenge these laws? Well, they're harmful. I'm assuming that most of the people on this webinar are familiar, intimately familiar with the harms of criminalization policy enforcement. And I'll just touch on a couple of them here. One, it worsens the homelessness crisis. Convictions on someone's record, even for misdemeanor crimes, can make someone ineligible for private housing. If they're competing for a rental unit, they may be excluded by virtue of a rental admission policy that excludes anyone that has any form of criminal conviction on their record, even a misdemeanor, and even if it's old, or for life-sustaining activities. It also can make someone ineligible for subsidized housing. Public housing authorities are the largest provider of affordable housing to the nation's poorest renters. And even that form of housing can be unavailable to somebody based on even an old misdemeanor conviction. It also, and this is the harmful impact that we'll focus most on today, enforcement of criminalization policies, which can include criminal penalties, but also other types of penalties like the ones that we just saw on the last slide, harm public health. It does that in a number of ways, and perhaps it's never been more clear how criminalization policies harm public health than now during the outbreak of the COVID-19 pandemic. I do advise everyone to take a look at the Housing Not Handcuffs 2019 report and the section of that report on how criminalization policies undermine public health. That report was drafted before the outbreak of the pandemic, but there's a lot of good research there. Also, please check out the Law Center's website. We have a coronavirus specific page with additional information to help you make the case that criminalization policies should not be enforced, at least during the COVID-19 pandemic period, because of its effect on public health. I'm going to talk really briefly about how and why criminalization policies undermine public health, but I'm going to turn it over to Dr. Fry, who's certainly much more expert on that than I am. One of the reasons is that when someone's tent, vehicle, or other private shelter option is removed, that person is unable to shelter in place. And the options available to them at that point are either to be unsheltered on the street, and that's really the reality for the majority of people, or they may be able to access a congregate shelter. Now, emergency shelters are not a solution to homelessness. Only housing is a solution to homelessness. So it's important that we all understand, just as a matter of interpretation of the role that emergency shelters play, they do not end homelessness. They are crisis interventions that give people a place to access shelter from the outdoor elements. But congregate shelters are not accessible to everyone who might be interested in using them, and they're also not appropriate for everyone who lacks private housing. I've listed on the left-hand side of your screen a number of common barriers to shelter access, and these all predate the COVID-19 pandemic. But there are some in the main part of the slide that I want to touch on here because they're all very relevant during the pandemic, when we know that physical distancing and adequate hygiene and adequate sanitation are critical to curbing the spread of the deadly virus. Congregate shelters are often crowded. That's because there are literally more human beings than there are shelter spaces in this country. Indeed, shelters are often full and turn people away, and that is true even in the current era where some large centers, convention centers, and similar settings have been temporarily set up to provide temporary shelter to people. Even those temporary accommodations are not always available because they're full. Also, congregate shelters offer, as we briefly mentioned before, only temporary accommodations. Sometimes they're available literally only overnight for a set number of hours in a day. Also, there may be stay limitations, meaning you can only stay for a certain number of nights in a given month because they're trying to, the shelter providers are trying to share the resource. Also, so they may be inaccessible to people with certain disabilities, and you'll hear more about that when we talk about the Bloom v. City of San Diego case and hear from Lily Graham, Counsel at Disability Rights California. The reason why we are talking about congregate shelters and COVID-19 is because physical distancing is difficult or impossible inside congregate shelters. The CDC has issued guidance surrounding safe sheltering. But even this guidance, which would include, and just a quick step back, the guidance that you're seeing here, we've taken in the bullets just a couple of pieces of the guidance. This represents the second guidance that the CDC has issued with respect to sheltered environments and people living in congregate shelter spaces. Even the new guidance, which has much stricter measures that should be followed inside of shelters to try to prevent spread of the disease within those environments. For example, physical barriers between beds, physical distancing practiced at meal times, and recommendations that everyone inside of a congregate facility wear a mask. Even those stricter measures are impracticable. People cannot remain physically distant as they travel from their bed to outside, use shared bathrooms, and in addition to coming into close physical proximity with other human beings, they will also come into proximity with shared surfaces. In fact, sometimes surfaces that are shared with hundreds, maybe even as many as 1,000 people in a given congregate shelter environment. And the more people that touch a surface, the higher the likelihood of potential COVID-19 transmission, because we know that the virus can live on surfaces, at least certain surfaces, for as much as 3 days. This is why, in addition to guidance for sheltered populations, the CDC has also issued guidance relevant to unsheltered populations of unhoused people. And the CDC recommends that unless individual housing units can be made available, governments should not be clearing encampments during the community spread of COVID-19, and instead should be enabling people to safely shelter in place in the outdoor spaces where they live and to provide them with the services they need to follow other CDC guidance that relate not only to physical distancing, but also to proper hand washing and sanitation and hygiene practices. The same rationale behind this guidance applies to people living in vehicles. So we at the Law Center, as well as our allies, read this guidance to mean not only tent encampments, but also people living in vehicles should not be displaced from those private shelter options unless another private shelter option that's adequate can be made available to them. But you don't have to take my word for it. We'll hear today from your fellow panelist, Dr. Elizabeth Fry, an MD, a Master of Public Health, and also a board member of the Street Medicine Institute. Thank you so much for being with us today, Dr. Fry.
Hi, thank you, Tristia. It's a pleasure to be with all of you as well. I am in the chat feature. I am going to add a link that you guys can click on for the Street Medicine Institute guidance on people experiencing unsheltered homelessness. And this is the intention of this publication was really more to provide guidance to people who are doing street medicine in the setting of the COVID-19 pandemic, but it may be helpful to you all to review as well. So, and the CDC, as we were developing these guidelines, we were working with folks from the CDC, from HUD, the Housing and Urban Development, in order to kind of create these. So a lot of the CDC guidance that was published about unsheltered homelessness is based on conversations that those of us from the Street Medicine Institute had with folks at CDC who also have specific experience working in health or public health fields with people experiencing homelessness. So there's that for you if you want it. I think that many of you may know this, but I'll just say it anyway, that people experiencing homelessness, whether they're sheltered or unsheltered, have poor health outcomes. They tend to present, by the time they do present for medical care, usually their health problems are pretty significantly advanced. And we are doing, as healthcare providers, more to sort of mitigate a worsening of those health issues than we are necessarily able to. We're not in sort of the prevention stage where we would address something prior to it becoming a problem. We're not even in the sort of intervention stage of like, now that it is a problem, I can prevent worse things from happening. We're usually at the stage of the worst things have already happened, and now we're trying to either improve a little bit or just maintain the health as it is now, to prevent people from dying. So that's kind of already the status of people's health, people experiencing homelessness, their health prior to the COVID-19 pandemic. What we do know prior to this pandemic as well, from a study in Massachusetts that was published in 2018, people who are sleeping in shelters are sort of a little more healthy than the people sleeping outside, which I think stands to reason because people sleeping outside, I think, have more difficult issues with trust and therefore more challenges in terms of going in to seek healthcare, but they're also exposed to the elements. From that study, we know that people experiencing homelessness, no matter what kind of homelessness it is, are about 10 times more likely to die during like 10-year period than the rest of the general population. That study also broke down comparing unsheltered to sheltered people, and unsheltered people were about 3 times more likely to die during the study period than the sheltered folks. Now, with COVID-19, we may see a significant change in that it is now a less healthy environment to be in a shelter than it is necessarily to be outdoors, because of the high likelihood of developing COVID-19, or at least testing positive for coronavirus if a person is sleeping in a shelter. And we've seen in places like Boston and San Francisco where they started testing asymptomatic people, and in Boston found that 1/3 of their staff and 1/3 of their people sleeping in the shelters were positive without any symptoms. And in San Francisco, I believe it was about 2/3 of the people sleeping inside the shelter tested positive, but I don't know how many of those people had symptoms. So I think we need to assume that coronavirus is in all the shelters pretty much in the United States, and that it's more of a matter of when someone will come into contact with it and end up testing positive versus if. So what we may see is sort of a narrowing of that health disparity between unsheltered and sheltered people during the time of coronavirus, because people who are living in shelters are more likely to catch coronavirus and therefore are likely to die from it as well, versus the unsheltered people may be slightly more likely to die if they get infected with coronavirus, but they are less likely overall to come into contact with somebody who has the virus when they're sleeping outside. And just in thinking about kind of the safety of different spaces that people have available to live in, and this sort of echoes what Tristia was saying, is that I think right now, in my professional opinion, the most dangerous place to be sleeping if you're experiencing homelessness is actually in a shelter. And for the reasons that Tristia listed, such as, sharing this, even if your beds are 6 feet apart, having to touch all of the same things, and the more people in one space, the more things that are being touched by everyone. And I know already that based on kind of my experience going into shelters and working in shelters, but also based on the reports that I've heard from my colleagues and from students who work in shelters in different cities, is that the hygiene capacity of shelters was already hugely limited prior to COVID-19. I think we can also fairly safely say that shelters are not getting a lot of income right now over what they were before. In fact, I think that charitable giving is likely to go down because of the economic impact of the pandemic, which means that it's not as if they have extra people to clean and sanitize surfaces at the regularity that would be needed. But also just in terms of the amount of bathroom capacity, a lot of places that I've been in and places that people have told me about are that there are, a couple of bathroom stalls for 100 people, which is pretty insufficient, and sometimes worse than that. And that shelters have policies, and I don't know if any of these have changed because of COVID-19, but that you have to stand in a different line to get to the toilet than you do to get to the shower. And so what that means practically is that if you've been waiting for 3 hours in a line to get to the shower and you have to go to the bathroom, you're probably going to go to the bathroom in the shower stall. So some friends that I work with up in Michigan had been telling me about the problem of defecation in terms of public health or health of people in the shelters, because a lot of people ended up having to use the bathroom in the shower stalls. Again, all that prior to COVID-19, but those are just the existing problems that we then exacerbated by coronavirus. So I also consider kind of these large convention centers that cities have opened up where they're housing, thousands of people potentially in their convention centers. I don't know how any of these convention centers are configured, but I'm willing to bet that it still involves a lot of people having contact with a lot of the same surfaces and doorknobs that you might have, if the convention center were full of people for some other reason. I don't know that people are being restricted to, only people in this room can use this bathroom and therefore we're limiting the number of people touching the same surfaces. I have no idea. But like I said, I consider convention centers maybe not that dissimilar from the shelter-based living. I think the appropriate use of convention centers are for people who have tested positive for COVID-19, but don't need to be in a hospital for it. Housing them together in sort of a field hospital inside a convention center, I think is probably an okay use of that space. But I think the other thing to consider is that a lot of those spaces are used to sort of co-locate people whose tests are pending with people who have already tested positive, which means that it is likely that the people who have that test pending are then further exposed to people with coronavirus. So even if they didn't have coronavirus before they went in, they might have gotten it from being in the same space. And that applies to hotels and motels and things like that too, that I'm seeing in some places. Cities are choosing to house all people who are being tested for COVID and who have COVID, and people who have high risk of death from COVID. They're housing them within the same hotel or motel. And to me, unless they have armed guards standing outside with weapons to keep people in their rooms, I think there's going to be a lot of intermingling of those populations and put the very vulnerable people who don't have COVID at risk of catching it because they're co-located. That brings us to safer places. So I think tents where people are sort of isolated off in the woods by themselves, not bad. Tents where people are sleeping in encampments, but the people in the encampment tend to kind of stay there and stay together, and they don't have a lot of people going in and out of them. And where people have tents in those encampments, I think that's not ideal, but it's better than being inside a shelter or a convention center. And then, I've worked a lot with the folks doing the case in San Diego and thinking about vehicles. An RV in which somebody has electricity and running water, I think we should consider no different from a single family home. And maybe even safer than people living in apartment buildings. I think beyond that, if people have an RV or just a truck or a car that they're sleeping inside, that provides a physical barrier between them and other people when they're sleeping or just when they're awake too, is again not a bad option. They'll obviously have to go out to use the bathroom and to get food and things like that, but way safer than either being in a tent or being in a sheltered location. So I want to stop. Well, let me just say one more thing. I'm sorry, Tristia, if I'm taking too much time. I think in terms of COVID-19, one thing that we also need to consider in terms of the actual health outcomes it is really kind of the mental health stuff, and that's where I specialize. But that there is this sort of, whether it's somebody who's needing ongoing treatment for their schizophrenia and they sleep outside or in a shelter, or whether it's somebody who's having kind of new onset anxiety because of everything that COVID brings. COVID is flavoring everything in terms of the type of care that people get, the anxiety about not being able to receive their medications or services, and then also the fears that people have about their own inherent vulnerabilities to dying, I think is being affected by COVID-19 as well. I would encourage you guys to think that so people experiencing homelessness are highly likely to have had some sort of traumatic experience either in childhood or adulthood prior to becoming homeless, and then also very likely to have had a traumatic experience after becoming homeless. But that not everybody in this pandemic is going to feel that the experience of coronavirus or COVID-19 is a trauma to them. And so I think that for some people, it may be that having the opportunity to move inside a hotel and get some good sleep and have groceries delivered to their door would actually be a really positive experience. But I think that what we're seeing is that for the majority of people experiencing homelessness right now, aside from any other mental health issues that they have, that anxiety, and I've experienced anxiety. I think all of us have experienced anxiety from this pandemic. That's really overwhelming and really pretty stressful, and potentially even traumatic for people. I'm going to turn it back over, but I am going to add one more link, which is an article about a street psychiatrist at Yale that I think is kind of helpful for, she talks about some of the COVID flavoring in terms of mental and physical health care that people are receiving right now. So again, just for you guys, if you want to be able to look at it. It looks like somebody else is going to have to send that to the rest of the group because only the organizers and panelists are able to see it. All right, well, thank you so much.
Thank you, Dr. Fry. We will share both of the links that you've shared with the larger audience, and we really appreciate your commentary. I think that helps give us a good overview of how and why loss of individual tents, vehicles, and other private structures can put someone at increased risk of exposure, particularly if they are forced under penalty of law into a congregate shelter or seek out a congregate shelter in order to replace their basic shelter from the elements. And that increased risk is relevant to the challenges that we'll talk about today, because it goes to both risk of bodily harm, which is relevant to a state-created danger theory, and also accessibility of shelter, which is relevant to a cruel and unusual punishment theory. I just want to very quickly mention that the Law Center has a litigation manual. It's called the Housing Not Handcuffs Litigation Manual, also available on our website, that goes over a number of different constitutional theories that have been used to successfully challenge criminalization policies. The ones that we're talking about today are certainly not the only ones. Also, they're not necessarily the ones to use. There are a lot of strategic considerations, and we'll focus on that particularly as we talk about Eighth Amendment cruel and unusual punishment theories and Martin v. City of Boise. But it's important to note that just because a theory is available doesn't mean that it will be successful. Particularly, this next theory is a highly fact-specific theory. And so to the extent that it's helpful to know that there is this potential theory, we wanted to discuss it with you all today. So we are focusing today on substantive due process, in particular, state-created danger. There's a recognition that the Fifth and 14th Amendments provide a right to substantive due process. And substantive due process is the notion that due process not only protects certain legal procedures, but also protects certain fundamental rights and liberty interests. And among them is the right to bodily integrity. Now, there's no general duty on the part of the government to protect us from private violence or danger. So failure to do that does not generally violate due process guarantees, but there are a couple of exceptions to that general rule. One is the special relationship exception. We're not really going to be talking about that much today, but the special relationship exception and liability therein arises from the relationship between the state actor and a particular victim. So for example, when a person is held in custody and that person is deprived of something that they would need in order to maintain life and safety, because they're in custody and are not able to meet their own needs, their government has an enhanced duty to protect their bodily integrity. And there have been a couple of cases filed since the outbreak of COVID-19 that have raised the special relationship theory under either the Fifth and 14th Amendments and asking for people to be released from incarcerative settings like jails or ICE detention facilities. If you're interested in knowing more about those cases, do feel free to reach out to us. The one we're going to talk about today in more detail, though, is the second exception, which is referred to as state-created danger. And that's when a government affirmatively places an individual in danger by acting with deliberate indifference to a known or obvious danger. Before we get into discussing how that theory has come into play in San Diego, just a couple of things for our national audience to understand. There is no national standard for applying the state-created danger theory. Courts of appeals have adopted divergent tests for these types of claims, and indeed some circuits have not recognized the state-created danger doctrine, such as the Fifth Circuit, which includes states like Texas and Mississippi. Also, the 11th Circuit, which covers states like Florida and Alabama, does not recognize the state-created danger doctrine, instead has a higher standard for finding a substantive due process violation with respect to state actors. So, I note those exceptions, but they are not the general rule. Most jurisdictions do recognize the state-created danger theory, and there's a great deal of overlap between the respective tests. But they focus primarily on the three elements that are listed here on this slide. Going really quickly over these three elements. The state-created danger exception requires affirmative action by a state actor. So the government, the government needs to have done something affirmatively rather than failed to have done something. In most contexts, there's an exception in the Second Circuit, which I'm happy to talk about with anybody in the Second Circuit. But for the most part, you can only get to success under this theory if you can show the government has done something, either taken a tent away, taken a hygiene facility away, or removed a vehicle. Those are examples of things that can be considered affirmative action, and indeed, exposure to the elements, forced exposure to the elements, have in fact been found to be affirmative action of the type contemplated by substantive due process, as well as leaving somebody outside in a high crime area. Also, the state-created danger needs to have created or exposed a person to a known or obvious danger. Obviously, within the context of the COVID-19 pandemic, the known or obvious danger is exposure to the coronavirus. But there have been other types of known or obvious dangers that have been raised in the past. For example, the state-created danger theory has been used to challenge sweeps of encampments and removal of tents just prior to the onset of the winter months, when exposure to the outdoor elements carries an elevated risk of harm. These types of claims have not met with a large amount of success in the homelessness context. So we do not suggest that this is anything approaching a guaranteed winner in court. This is a theory that, again, is highly fact-specific, and you really do need to thread the needle. But the current nature of the current pandemic and the nature of the pandemic suggests that this is a theory that could prove successful in stopping bad practices like removal of tents and hygiene facilities, and may also be helpful in pushing back against forced entrance into congregate shelter facilities. In addition to affirmative action that creates or exposes a person to a known or obvious danger, and just as a side note, it needs to be a danger that would not, that the person would not have been exposed to otherwise. There's a case, Sanchez v. City of Fresno, where the court initially found that plaintiffs had stated a claim under the state-created danger theory and denied the defendant's motion to dismiss that theory when they showed that the city intended to sweep the encampment just prior to the onset of the winter months. However, ultimately that theory was not successful, and the court declined to opine on the merits, other than to say that the harms of exposure to the outdoor elements pre-existed the activity by the city of Fresno. So, it's okay for the danger to exist, but the exposure to the danger must be something that has been created by that governmental affirmative action in order to satisfy those first two prongs. Then the last prong, deliberate indifference to the risk of serious harm. With COVID-19, we're all very familiar with the type of serious harm, and people become very sick, and there's a heightened likelihood of death as compared with similar viruses. And those certainly would qualify as serious harms, but a court needs to find that the state actor, when affirmatively acting, is aware of or should be aware of and disregards that substantial risk of serious harm. This typically requires more than mere negligence or a lack of due care. And in some jurisdictions, it would require indifference to harm that shocks the conscience of the court. Shocking the conscience of the court can be actions that are intended to injure a specific person, or that are just not justified at all by a legitimate government interest. Also, a court may find that its conscience is shocked when a state actor has time to reflect and make reasoned and calculated decisions, but still acts with deliberate indifference to the elevated risk of harm that their action creates. And in that scenario, a court may find that that's significant enough to be conscience shocking. Now, I am going to move along to our next presenter, who will talk about how this theory has been put to use in San Diego. But really quickly, before I do that, I wanted to mention a few things about San Diego. San Diego is not a place where racial disproportionality in the homelessness population is particularly acute. But that is not to say that it isn't acute. It's just not particularly so. And that is a result of there being gross disproportionality in the general homeless population nationwide. Nationwide, some 60% of people experiencing homelessness are people of color. And I want us to keep that in mind as we think about the people who are being affected and dying from COVID-19. The news reports shows that there's a disparate racial impact there as well. And all of that, I think, is really important as we think about how and why these theories are important, and how to use these facts in our advocacy, either inside a courtroom or outside of a courtroom. So touching, quickly on race and homelessness in San Diego, people of color, particularly Black people, are disproportionately experiencing homelessness on a national level. And in San Diego, the disparity between the percentage of the general population that is Black compared to the homeless population is drastic. Black people only make up 6% of San Diego County's population, but they make up over 25% of the county's homeless population, or at least that was the case pursuant to the data from the 2018 point in time count. Among the youth homeless population, Black and Latinx youth experience homelessness at higher rates than white youth in San Diego County. And these racial disparities exist in ways that leave people not only vulnerable to unnecessary contact with the criminal justice system, but also exposure to illness or even death from COVID-19. For folks who are interested in racial equity and COVID-19 data, again, please do check out the Law Center's coronavirus webpage. We have a fact sheet available for you there. In addition to racial disproportionality, there's also disproportionality among people with disabilities that are also people experiencing homelessness. And with that, I will introduce our next presenter, Lily Graham. A lot of you listening to this webinar are going to be familiar with her and her excellent work. She is now litigation counsel at Disability Rights California. She's also co-counsel in the lawsuit Bloom v. City of San Diego. And she will talk about how the plaintiffs in Bloom v. City of San Diego, which are 11 named individuals and a putative class of people living in vehicles in the city, are using the state-created danger theory to seek emergency relief from the federal court there. With that, take it away, Lily.
Thank you, Tristia. Thank you for having me. I'm going to talk about Bloom. I am sorry, I just realized I have a typo on the first page. It should be Bloom et al. Versus the City of San Diego, and it's the class that it's a class action lawsuit against the City of San Diego. The primary class is on behalf of homeless individuals who rely on their vehicles as housing. But I wanted to step back very quickly on the housing crisis and the homelessness crisis in California. So as many people know, and it's very common knowledge, there is a housing crisis in California. And in the homelessness crisis, I think the last count I saw was there's an estimate of 151,000 people who are homeless in California. And the reason I bring that up is because of the cost of housing in California, the homelessness rate seems to keep increasing. And so you find a lot of people find alternatives or what some affordable housing advocates will call living in the margins of housing. And so examples that and advocacies that we've worked on are, for example, people who live in motels long-term as opposed to a short-term place because of the cost of motels. And you start seeing that also in people who, when they lose their housing or they're evicted, they start living in their vehicles. And as Tristia mentioned, that rate is also increasing. What's interesting is with the pandemic, you start seeing that, you know, the homelessness crisis, the policies, procedures that have been rolled out haven't worked. And there's a lot of, we would say, failed policies. And it's shocking and incredibly disheartening to see that it's even further worsened during this pandemic, especially for people who are homeless. So I think Dr. Fry and Tristia touched on this. Shelters play an important role in solutions for homelessness. If you are losing your housing and you can access a shelter and stay for a short time, which is what they're intended for, then you could, you know, get back on your feet, and that happens for many. But in California, oftentimes a shelter becomes a long-term place, and I think one of the key issues that we see in shelter is in its limitation and implementation is that the shelters are not accessible, as Tristia mentioned. And so I wanted I wanted to kind of provide that background information because all those facts are also true in Bloom. The affordable housing crisis in Bloom in San Diego is huge. There's a huge housing crisis. I think one of the documents that we submitted in support of our class certification brief is that in order to provide enough affordable housing in San Diego, the County of San Diego needs to look at upwards of 100,000 affordable housing units. So there's a big affordable housing crisis. So you see people living in alternative places like their vehicle, and they're able to stabilize. You know, I've worked for a while with homeless individuals, and you see the ability to for a person to find health and financial stability for a person that is in their vehicle versus someone on the streets. Someone in a vehicle, like our clients, our named plaintiffs, are able to keep a hold of their medication, their paperwork, They're able to, specifically for the individual with disability, manage the symptoms of their disability because they have this private space, a place to store their belongings. Their ability to manage their health and their disability just increases, and there's a lot more stability. So the next page, a little bit of facts of the case. The case challenges two city ordinances. One is the restrictions on having an oversized vehicle, and the second is the vehicle habitation ordinance. And what happened in this case is the plaintiffs filed a preliminary injunction. The preliminary injunction was granted on the vehicle habitation ordinance. And you'll see this in a lot of litigation, a lot of cases, and a lot of advocacy in various jurisdictions, is cities will start legislating around court orders. So here, when the judge issued a preliminary injunction for the older vehicle habitation ordinance, the city legislated around that court order and issued a new ordinance on vehicle habitation ordinance. And so recently the court allowed us to amend our complaint to add this new vehicle habitation ordinance. The class that is being sought in Bloom is, the main class is homeless individuals who rely on their vehicles as shelters and homes. We also have a subclass for people with disabilities. And a piece of that is the lack of an accommodation process throughout the city. The first reasonable modification request that was made on behalf of our plaintiff was on March 30th, 2017. The city never effectively responded. They did not address or engage in the interactive process as to how someone who is living in their vehicle is not able to access the shelter. So for example, we had a client who, in order to do her day-to-day activities, go to the store, go to a doctor's appointment, she would have to rest. She had, from a car accident, a broken back, and in order, after just an activity like grocery shopping, she would have to lay on her medically appropriate bed to rest. And she was part of one of our plaintiffs who made a reasonable modification request. And she wasn't someone that was able to shelter in place, or I'm sorry, utilize a shelter. And so and the city never responded to this reasonable modification request from the plaintiffs. So it just lacked in general an accommodation process on the city's policy. But there is also a lack of accommodation process within the shelters. So if someone wanted to be in the shelters and believe they can be in the shelters with some accommodation, there's a lack of a process there as well. And because of that, it severely limits the ability for people with disabilities to utilize San Diego's shelters. The next slide. So that's our class definition. So how has COVID-19 affected homeless individuals in San Diego? What is very interesting to me as we were putting together the temporary restraining order is that the city's policy for San Diego residents was to shelter in place. So if you had a home, you were to remain in your shelter. If you didn't have your home, you are not able to actually shelter in place when we track the policies unless you have contracted COVID-19. So it's completely opposite, right? The policies, the public health directives from the CDC and what Dr. Fry mentioned for people who are homeless. So what I mean by that is what we saw in San Diego. They opened a 1,500 person emergency shelter at the San Diego Convention Center. One of the reasons was to decongregate the congregate the existing shelters. So the existing shelters they had were at capacity or too full, and there was no way they could follow the CDC guidelines. So they moved people into the San Diego Convention Center. That was projected to be, it should have been around 900 people. They also started to do sweeps around San Diego, pushing people into the San Diego Convention Center. Advocates, local advocates, homeless individuals, there was a lot of concern, including public health officials, around whether a 1,500 person emergency shelter was a good idea. The picture shows there were no privacy, there was no walls between the cots. There was a lot of concerns about bathroom and hygiene. April 16th, we found out that 2 people tested positive for COVID-19 at the San Diego Convention Center. And so when I talk about the opposite policies that are available to homeless individuals, where the CDC provided guidance that someone, if you were in an encampment and you were able to socially distance, that is preferred than going to an emergency shelter. If someone is in a vehicle, they are able to socially distance and also manage their symptoms, manage their health, and manage their disabilities, as we had initially pled in this case. But even more so, it's important during the COVID-19 that they can maintain that social distance. They have access, many have access to bathrooms within their RVs. But what do we see from San Diego? And again, going back to what Tristia said, state-created danger is such a fact-intensive claim. What we saw in San Diego, and we believe we met the threshold, is that San Diego police officers were impounding people's vehicle, knowing that they would either be on the street or have to go into the congregate shelter. The client that, the declarant that we had who had their vehicle impounded, and this was April 10th, so weeks after the shelter in place came in place, knew that our client was homeless, knew that that was a vehicle they intended to live in, but they still impounded, and the person ended up on the street. The declarant's partner had congestive heart failure, and resulted them in being in the streets. Individual on the streets were warned and decided to move away. They closed public bathrooms. The RV dump sites were closed. During the meet and confer process, they opened one back up. But the most essential piece of mitigation or prevention of COVID-19 is hygiene. And here they were closing access to these important facilities. The other thing was the inability to access bathrooms at business and electricity. One of the things, and I meant to add food as well. Our clients, you know, many businesses are closed right now, and our clients rely on local businesses, not just the government for the public bathrooms, but they also rely on businesses, right? Going to a Starbucks to plug in one of our clients, his CPAP machine for breathing, and using the restroom, and charging their phones, phone being an essential item to connect. And those are no longer available. So when you don't have private business available, and then on top of that, the government is closing these essential facilities, their condition is worsened. The next slide, please. Oh, thank you. So we have a pending request for a temporary restraining order before Judge Battaglia at the Southern District in California. And I laid out here specifically what we're saying that the city has done. So they know our clients are vulnerable and homeless. They've known for years. And our reasonable modification request goes back as far as 2017. And they know that our clients and putative class members rely on their vehicles for safe shelter. The city does not have sufficient or adequate alternatives. One of their alternatives is supposedly the 1,500 person emergency shelter. And we know under CDC guidelines, public health officials, and the people who tested positive, that is not a sufficient or adequate alternative. We also heard anecdotally that some folks who were cited or enforced against on the street and were told to go to the convention center, because of the inability to access the service providers who allow admission into the convention center, were not even able to get into the convention center. So that linkage between enforcement, law enforcement, citing, ticketing, criminalization to these shelters, that linkage, which was really required under Boise, that linkage might not be there in a lot of instances because of the limited service providers that are out there right now. City refused to halt enforcement of the ordinances, and finally, they endangered plaintiffs by closing bathrooms and other facilities. So what do we want? We want a halt of the enforcement, a halt of both of enforcement under the two ordinances, and the ability to practice mitigation efforts during the pandemic, and specifically for clients to stay in their vehicles, access public restrooms, have access to the dump site so they can keep their vehicles hygienic, and parking. Because one of the things that makes sense for all of us to go to a bathroom, we have to park somewhere. And in some instances, the city said, oh, well, you can go to the restroom, but they weren't able to park anywhere nearby the restroom. And so if you're not able to park, you're essentially not, that bathroom is not available to you. And lastly, the state created danger. So I laid out here the elements of the substantive due process claims. I've gone over our arguments during this presentation, but I just wanted to show you how we laid it out, that the city made affirmative conduct. They knew or know of the danger. So they know they were provided all the CDC guidelines. That's incorporated into their programs. And what's really interesting is these programs that they've recently rolled out under COVID-19 is a lot of it is state funded. In the same state funding, the state is providing trailers, at least 1,300 trailers across the state for homeless individuals to socially distance and maintain their health. And here, San Diego is taking away people's mobile home, or I'm sorry, RVs or motorhomes. We believe it's deliberate indifference to the known or obvious dangers, and it's placing people in worse conditions. And we offer declarations that show how our clients are in worse conditions because of the city's action. And just really, and lastly, I just want to emphasize, I believe our declaration really tells the story of how, of the harm our clients have gone to, the irreparable harm, which is the standard in a temporary restraining order. And so we really want to just emphasize the factual requirements for a state-created danger claim.
Thank you so much, Lily. That was great, and highlights how the theory that we talked about here on the webinar has been put into action in at least one case. And we suggest it as a tool for you. Again, I want to emphasize that anything that we talk about on this webinar series are meant to be tools to assist you in your advocacy. They are not to be construed as advice. We're not advising anyone to run out and start filing state-created danger claims. Again, you really need to have the right facts, but we think that the COVID-19 pandemic and ongoing criminalization of homelessness, at least in certain communities, provide those facts. And this is a tool available for your use. You'll hear on our webinar series other tools. I am mindful of time, so I want to touch very quickly on another theory. It's fine that we're giving this one a little bit shorter time because you've heard the Law Center talk a lot about the Eighth Amendment cruel and unusual punishment theory and Martin v. City of Boise. Feel free to reach out if you would like to talk in more detail about how this theory can be used during the COVID-19 pandemic. But again, referencing CDC guidance and what Dr. Fry explained about the increased risk of harm, there is an argument theoretically available to someone who might argue that a person subject to criminal penalty for the resting activities of sleeping, sitting, or lying down does not have access to an indoor shelter space so long as it is a congregate indoor shelter space, particularly if it is not following current CDC guidelines with respect to those environments. And again, we'd point out that the latest CDC guidance has made the measures that should be taken inside of congregate shelter facilities even stricter. Now, we don't, again, we are not advising people to go out and file these types of claims. You're probably all very familiar with the procedural history of Martin v. City of Boise. The City of Boise not only petitioned the Ninth Circuit for rehearing en banc, which was denied, but also petitioned the U.S. Supreme Court to review the decision. The Supreme Court declined and offered no position, but that does not mean that they would find favorably for plaintiffs if there were another case that comes before it. And since Martin, the Eighth Amendment has not been particularly successful at stopping some of the bad practices that we're talking about here. Like, for example, in the context of sweeps, the Eighth Amendment cruel and unusual punishment theory, even post-Martin, has not stopped sweeps, and a couple of courts in the Northern District of California have declined to order emergency relief, even when it was clear that people were going to be subject to a sweep and lose access to their tents. Now, we don't say this to discourage any good Eighth Amendment claims, but be aware of the narrow holding in Martin. It covers resting activities. It does not explicitly cover sheltering activities. It is one where criminal penalties are directly relevant in order to establish standing. In the Ninth Circuit, a credible threat of criminal enforcement can be enough to establish standing. In a place like the Fifth Circuit that covers Texas, for example, you need to have actually been convicted before you would have standing to raise an Eighth Amendment cruel and unusual punishment claim. So we offer the Eighth Amendment cruel and unusual punishment theory as another tool to add to your advocacy toolbox. And that could be, a toolbox that you deploy both inside of courtrooms and outside of courtrooms. There's a lot of kind of intuitiveness about the cruel nature of enforcing these criminalization policies, particularly in light of the COVID-19 pandemic. And even if a case were not to be filed, we think that the language in Martin, and some of which we quote here, could be helpful to include in demand letters or other contacts, op-eds and communications work, and out of courtroom advocacy. Again, the Law Center has recommendations specific to COVID-19 and what we'd like to see governments do in response. This lists them. You can find all of them on our COVID-19 webpage. It's our URL /coronavirus. And you can find it very easily if you just go to www.nlchp.org. There you will also find a template letter. We're encouraging everyone using the guidance that's highlighted here in yellow to take action by issuing letters. Contact your governments, let them know that you and the Law Center and the Housing Not Handcuffs campaign are asking for governments to respond appropriately to the COVID-19 pandemic and ensure that people who lack housing are able to remain safe, not only for their sakes, but for the sake of everyone in the community. Thanks so much for the folks who have stuck around. We're wrapping up now. If you can participate quickly in a poll, we could launch this poll question. The poll just asks whether you will use what you learned today in your advocacy, in or outside of the courtroom, on behalf of people experiencing homelessness during the COVID-19 pandemic and beyond. And I think that poll's popping up here. We've got, 2 options, yes or no, for as many people as are able to complete that poll. We would greatly appreciate it. And we're waiting for responses. And it looks like this is great. 99% of you said that you will use the information that you learned today in the future, which is just fantastic. Please contact us. As I mentioned at the outset of the series, this is a webinar series. So this is, webinar 2. We want to bring you content that's useful to you. We are here to support your advocacy. We do that not only through this webinar series and the work we talked about today, but also through the Housing Not Handcuffs campaign. That is a campaign of hundreds of organizations and even more individuals that have endorsed the premise that governments should be working toward housing people and not criminalizing them. If you go to housingnothandcuffs.org, you'll find a lot of great resources in addition to the resources that are on the Law Center's website. Please follow us on Twitter. You've got our handle down there. Please use the Housing Not Handcuffs hashtag so that we can elevate the Housing Not Handcuffs message. Please consider donating to the Law Center. We are a nonprofit organization that relies on donations from good folks like you. So to the extent you're able to donate, no matter how large or small, that would be helpful to us, and there's the link to do that. And finally, if you would like to contact me, you're all welcome to do so. Again, my name is Tristia Bauman. I'm a senior attorney at the Law Center. You've got my you have my email address there. You also have, again, the Law Center's Twitter handle. That's also our Instagram handle. And then you've got my Twitter handle @GotNoPlace, which is short for Got No Place Like Home. Thank you all very much for joining us today. We really appreciate you spending some extra time with us. Thank you so much for your presentations, Dr. Fry and Lily Graham. We apologize that we weren't able to get to questions. To the extent that these questions are ones that we're able to answer individually, we will do so. But tune in to the next webinar, which will be 2 weeks from today, same time, same bat channel, and we will see you in 2 weeks. Thank you.